Welcome back to Pace Law Firm, pacelawfirm.com. Joined once again by Pat Deluisio, lawyer at Pace Law Firm. Pat, today we're talking about limitation periods. So I get into an accident and I have, let's say a week, 2 weeks, 3 weeks go by, and then I decide I'm not feeling well, and that's when I want to bring about a claim. Am I doing something wrong?
You're not doing anything wrong. I mean, you don't want to commence a claim if you're not injured. Usually when someone's injured, that's when they realize they have a claim.
Right.
There are two components to car accident cases. There's an accident benefits component where you claim benefits from your own car insurance. There's a tort component where you would be claiming from a third party for negligence causing the accident. When it comes to tort, the basic limitation period is 2 years from the date of the accident. Now, the law actually reads from the day that you ought to have known that an action has arisen. So, that 2 years may be the date of the accident. It may be that you don't discover you have a torn shoulder for some months after the accident, and that's maybe when your claim arises. It really depends on the facts of the case, the circumstances of the case, but a basic parameter would be 2 years from the date of the accident. As far as the accident benefits go, most policies, insurance companies, they state that you have to let them know within 7 days of getting in a motor vehicle accident.
Okay.
You also have 30 days to apply for accident benefits. So those are time periods to keep in mind. Now, there are exceptions to those rules. It really depends on, are you in hospital? Are you able to recognize your injuries? Those types of things. But really depends on each case-by-case basis. But those timelines that I'm giving you are parameters that everyone should keep in mind.
So 7 days to report the accident, 30 days for the accident benefits, but if it's a tort claim, if you're going after the third party for negligence, then it's 2 years.
That's right.
Okay, so what is that, like? Would the defense be sometimes that the longer you wait, someone could argue, well, no, inside that 2 years that you waited, you were actually injured another time through something else and aggravated it. Therefore, it's not the fault of the accident. How does that come into play?
Yeah, I mean, the earlier you can commence your action, the earlier you can at least put the other side on notice that you're, thinking about commencing an action. There's many benefits to that. One is the example you just gave. There'd be less question as to incidents arising after the accident that you may have been injured in. Another concern is that interest, prejudgment interest, which is something you can be awarded for when you have damages in a car accident.
Oh, okay.
It begins at the time you put the third party on notice, not at the time of the accident. So you actually have to formally put them on notice that they may be sued for negligence or in tort.
Right.
So it is important to action these things quickly. It's important to contact a lawyer or a paralegal that may be able to guide you down the right path and get you started.
Okay. Now, last question. If, let's say, someone is watching this video and they've gone beyond the 2 years, but they believe that this accident has caused them some pain and suffering and that they're still dealing with, can they talk to you now and maybe still get some help?
It's an uphill battle, but it doesn't always preclude you from recovering. It really depends on when you notice the pain arising, when you received a medical diagnosis, when you first reported these complaints. There is exceptions to the rule, so it's always good to get an opinion of a lawyer and make a decision from there.
Great. Pat, thanks for coming by. We'll talk to you again soon. That's Pat Deluisio, pacelawfirm.com. We'll see you next time. Bye-bye.